let's discuss about principles of contract law today. Now, as quantity surveyors, we are always working as contract administrators or contract managers, and we would be the first point of contractual administrators in our construction industry. So it's very important that we have a good understanding about the principles of contract law, how a contract would be formed and how it should be administered. So today, let's discuss about what is a contract, and then how or what are the elements that you need to have form a legally binding, legally enforceable contract. Right. So what is a contract? Uh, a contract is an enforceable agreement between two or more parties to do or not to do something. All right. A contract will define what a party's rights and obligations are and provide it with a means of enforcing its rights. Fundamentally, contracts allocate risks between parties. Right? Now, if you take that into construction contract context, uh, an example for a right is that the employer would require the building or the project to be completed on time with the required quality specified in the contract. So that is his right. And his obligation is to pay the contractor timely. And when it comes to the contractor, his right is to get the payment on time. His obligation is to deliver the project on time as well as within the required quality parameters. So you can see one party's rights becomes the obligation of the other party, right? So the contract is the tool that we establish the rights and obligations of the party, and it will allocate the risk between parties as well, right? Now let's discuss what are the essential elements that a contract should have to become a legally enforceable contract. Now, first thing is there should be legal capacity. Now, there are two types of persons in the legal systems: natural persons and artificial persons. So, the natural person are the people like us, and in order to have the capacity to enter into contracts, the natural person should not be minors and should be mentally sound. So most of the countries probably age 18 plus considered as adults or not minors, and you should be mentally sound in order to enter into contracts. And the artificial persons, that is what is more relevant to us. Artificial persons are the companies or the authorities and those kind of agencies. So the artificial persons will have given their authority for people in their organizations to sign the contracts. So the capacity of the artificial persons is whether the person who signs that contract has the legal authority to sign the contracts. So that is the capacity. So that is the first element, right? So when you come to the second element, that is the offer. There should be an offer. An offer can be oral, written, or by conduct. So it's an expression by words or conduct of a willingness to enter into a legally binding contract. Example, I might be making an offer to buy your car. That is the offer. And I will, in that situation, would be the offeror who is making the offer. And you will become the offeree, the person who receives the offer, called offeree. And another important aspect is the difference between invitation to trade and offer or invitation to offer. Now, like paper advertisements, tender invitations, or pre-contractual communications between parties are considered as invitation to trade. Those are not offers. Right. Now, there are basically four ways that an offer can be terminated. One is offer can be rejected by the offeree. So that is one. The other thing is offeree can issue or can give a counter offer. Then the offer would be rejected or terminated. The third thing is the offeree has not accepted the offer within a reasonable time period. Now that will be subject to the particular jurisdiction where they might have some reasonable time periods to offer to be accepted. So that is based on the jurisdiction. Or the offeror can put a fixed period or validity period to the offer, and if it expired before the offeree has been accepted that, then the offer would be terminated. The fourth thing is the offeror can revoke the offer. So before the offer has been accepted, he can revoke the offer, right? So those are the ways of terminating offer, right? Then the third element, the important element is acceptance. The acceptance also can be oral, written, or by conduct. And acceptance must be a mirror image of the offer. That means it should be unconditional, right? So it's unconditional willingness to bound by the offer, right? Now, for example, you might have two cars, right? And one is worth $20,000, the other one is worth $30,000. And now I am saying I will buy your car for $20,000. So I make the offer now. But you might say, no, I want it. I want 25,000 for that car. Now what you are doing is you effectively reject my offer by giving a count offer. Now previously I was the offeror, you were the offeree, and now you become the offeror by giving me a 25,000 offer, right? So now I become the offeree. Now if I accept it, then there would be a contract for $25,000. All right. So that is called count offer, right? So count offer will automatically reject the previous offer, and you cannot go back again, right? Now the fourth element is consideration. Now consideration is a valuable benefit given by the offeree to the offeror in return of the original offer or original promise. Now in the original example we discussed, I offered to pay $20,000 to your car, and you promised to give me the car. So car is the consideration in that situation, right? So there should be a valuable benefit. The consideration should be sufficient but need not to be adequate, right? I mean, that means maybe your car worth $30,000 or $40,000 in the market, but I offered 20,000 and you accepted it, right? So I mean, you can make bad bargains. That doesn't matter, or that will not affect the consideration. Consideration should be sufficient, not need to be adequate. All right. I hope you understand that. You don't need to meet the market value always with the consideration. Yeah. Right. The fifth element is meeting of minds, or in Latin, consensus ad idem, or mutual agreement. Now, if it relates to the example we discussed, now you have two cars. One is $20,000, the other one is $30,000. Now, when I'm making the offer, in my mind, I might be giving this offer to the $30,000 worth car. All right. And you might think that it is for the 20,000 worth car. And I give the offer and you accept it. But my mind is in this way and your mind is in the other way. So we are not meeting our minds. So in that situation, there won't be a valid enforceable contract. We are not meeting our minds. We are not talking about the same thing. Now, when it comes to the construction, it is about the terms. Whether we are agreeing both terms and we are in the same mindset of the terms. Have we agreed in the same terms? So that is the fifth element that we need to have. Number 6 is proper form. Some type of contracts, and in some jurisdictions they need a type of form to be done. For example, a contract runs more than 1 year, you might need to do that in writing, right? And real estate type of contracts, construction contracts, you might have to do it in writing as per the legal requirements. So that proper form should be there also. So the seventh element is there should be an intention to create legal binding. Now, in commercial agreements, which we are talking about the construction contracts, obviously parties have the intention to create legal relationships. They have the intention to bring this case to the courts if it requires to. So bring the contract to the courts. So there is a commercial, or there's an intention to create legal agreements. So that is important. But for example, like family or social agreements, where you have agreements with your family members or your friends, then you might not have that intention to create legal bindings. So that will not form a contract there, right? But in commercial agreements, what we are discussing now has an intention to create legal binding, and that is an important element. Number 8, legality. The contract should be legal, and it should be in 3 forms. It should be legal. I mean, like, the purpose of the contract should be legal. You cannot enter into contracts where the subject matter is illegal, right? I don't have to give examples. I believe you can imagine the examples. That is purpose. The procurement of the contract should be legal. For example, when you enter into a contract, maybe there's a bribe has happened, then it is illegal. The procurement of the contract is illegal. And the execution, when you execute the contract, again, if there are some illegal things happens, then that would be a problem. So for example, like when the execution happens, there had a bribe has happened, then the contract might be illegal. So the legality we can discuss in purpose of the contract, procurement of the contract, and execution of the contract. It should be legal. So that is the 8th element. The 9th element is in certain jurisdictions, especially where you have Sharia compliant legal systems, you have a requirement for good faith and fair dealings. So that is also an important aspect that you need to consider in your contract, or it's a part of the elements of the contract in order to have a valid, enforceable contract. I hope you got a basic understanding about what is a contract and what are the essential elements you need to have in order to form a valid, enforceable, legally enforceable contract. Thank you.